Hey everyone, welcome to the federal rollback of Obama-era non-discrimination rule, What Californians Should Know webinar. Thank you all so much for joining us. Thanks to our speakers for taking the time to speak today. And we're really thrilled to have such great participation on this webinar. My name is Kiran Savage. I'm the Executive Director of the California Pan-Ethnic Health Network, or CPEHN. We are a statewide multicultural health advocacy organization dedicated to the elimination of health disparities in California and in the nation. We are holding this webinar today to provide, I think, some important information on what has and has not changed for Californians as a result of a recent action by the Trump administration related to your healthcare rights. Since the passage of the Affordable Care Act and Section 1557's non-discrimination protections, CPEHN has worked to educate Californians about their non-discrimination rights, particularly related to limited English proficient individuals, as well as LGBTQ plus individuals and people with disabilities. So this issue is very important to us because we believe that all Californians should have access to quality health care. On June 12th, the Trump administration issued final changes to the Section 1557 rule, which will make it harder for women, LGBTQ+, LEP, and people with disabilities to get the care they need, and which also creates significant confusion for communities of color in the midst of COVID-19 and racial violence, particularly against Black communities. We know this is something that the Trump administration has been doing throughout their tenure, attacking communities of color, LGBTQ plus communities, immigrants, people with disabilities. So this is not new, but we continue to fight back and to make it clear that this is unacceptable. And we are very lucky in California to have legislators and other policymakers who both stand up to the Trump administration and who have worked to codify some of these essential non-discrimination protections in California law so that your healthcare rights cannot be taken away from you by the Trump administration. The goal of today's webinar is to first and foremost dispel any confusion about the Trump administration's rollback of Section 1557. It is also to clarify the protections that are still in place for limited English proficient, LGBTQ+, people with disabilities, and women. And at the end, we will be providing information on where to go if you think you may have been a victim of discrimination in healthcare in our state. And we will be providing you with that information so that you can take action to protect your rights. So we're going to be giving you quite a bit of information in this 1-hour webinar. And so I hope that the slides are helpful. If you have questions, you can certainly put them in the chat function. You can use the questions feature to share those questions. We will do our best to answer your questions at the end of the webinar, and if we don't get to them, you're welcome to follow up with us. And we also would encourage you to reference the fact sheet that we will be providing to all attendees as a resource for today's call. We may not have time to get to all of your questions, but we are going to do our very best. So that you know, as a matter of housekeeping, you are in listen-only mode, and we will be keeping it that way for the duration of the webinar due to the number of participants. But the webinar will be recorded, and we will share both the slides, the recording, and the fact sheet I mentioned after the webinar. So we hope that that is a helpful resource, and you are welcome to share all of those materials with your colleagues and community members. So to kick us off here, as our first speaker, I'm really thrilled to introduce you to Assemblymember David Chiu, who's been a key ally on these issues, working with communities to ensure that we preserve our healthcare rights in California. Assemblymember Chiu represents the 17th Assembly District, which includes San Francisco, and is the chair of the API Legislative Caucus. So thanks so much for joining us today, Assemblymember, and let me turn it over to you to give some remarks.
Great, thank you so much, and appreciate being invited. I really want to thank CPEHN for your leadership, and apologies for the messy backdrop I have behind me right now. So I'm David Chiu, honored to represent San Francisco in the California State Assembly. but probably most relevantly for this conversation, I am the chair of the API Legislative Caucus, and am among one of many, many leaders, not just from our caucus, but from our legislature, who are incredibly concerned about the recent announcements. For us, we're concerned about these rules really in two dimensions. First, the fact that this rule would remove non-discriminatory protections for our LGBTQ communities when it comes to healthcare and health insurance. This really is, again, part of Donald Trump's latest attacks on vulnerable communities and vulnerable Americans. This was particularly callous from our perspective for a couple reasons. One, the announcement was made on the anniversary of the Pulse Club tragedy that had an incredible ripple effect on all of our communities, particularly within our LGBT community. And then secondly, it's an announcement that is having a chilling effect for LGBTQ individuals who are seeking care during this time of heightened need during a pandemic when health access is critical. Our API caucus is also very troubled about the rule because it weakens requirements to aid individuals for whom English is not their first language. So LEP, limited English proficient individuals, by no longer requiring plans and providers to provide notices and information in one's native language, now instead allowing providers to take, quote, reasonable steps to do so. During this time period, our API community members have been experiencing tremendous challenges and barriers to accessing healthcare. We've been seeing the challenges of language access on many, many fronts, but particularly when it comes to healthcare, particularly at a time when communities of color and immigrant communities are already experiencing intense health disparities, we are exacerbating that because of information that we're not passing along. We know at this moment that API communities will have to turn to other sources of information, such as community organizations who often may not have capacity or expertise to answer questions. So this is putting an incredible strain on many aspects of our stretched systems at this point. And we're really concerned that if information isn't being provided, that individuals from our community will be getting incorrect information, which could lead to more harm. This is challenging in a state like California, but fortunately in our state, we do have some protections around language access and providing information to immigrant communities. We can't imagine what's gone on in other states where these protections don't exist. So on behalf of our caucus, I'm just here to stand in solidarity with others who are raising concerns about this. We need to fight what the Trump administration has done yet again. And those of us in our API caucus, we look forward to joining with other allies to be part of this fight. Back to you.
Thanks so much, Assemblymember. Thanks for joining us and for those comments and for your leadership on these issues. I'm now going to turn it over to CPEHN's Senior Policy Director, Carrie Sanders, who's going to focus primarily on what this rule change means for LEP communities in California. Carrie, over to you.
Hi, everyone. Thank you for joining us today. Really happy to be here. I know you've heard a lot about Section 1557, but I want to take a minute just to provide some general background on the law, what the Trump administration rule change does, and your rights generally, and more specifically with regards to language access in California. Next slide, please. So Section 1557 is also known as the Healthcare Rights Law. It's a provision under the Affordable Care Act that prohibits discrimination in healthcare settings for women, LGBTQ+, limited English proficient, and persons with disabilities in healthcare settings. The provision was built off of existing federal civil rights protections, so very important to note. Specifically, for example, with language access, there were protections, Title IV of the Civil Rights Act of 1964, as well as other protections that make it so that individuals have the right to access healthcare in their language. The 1557 applies specifically to health programs or activities that receive federal financial assistance. Any activity or program administered by a federal executive agency and any entity established under Title I of the ACA, which includes the health insurance marketplaces. Next slide. So Section 1557, the final rule that we're talking about today, is the rule, the implementing regulation of the healthcare rights law. It's an Obama-era rule that established particular principles and rules with regards to language assistance, including that healthcare entities post notifications of non-discrimination and the availability of free language assistance, including interpreters and translated documents, in physical facilities, on their websites, and significant communications. It also required these entities to provide taglines notifying individuals of language assistance services in the top 15 languages of the state, and to develop language access plans. While the Trump rule eliminates these requirements as part of their rule change, the ACA and Section 1557, as well as the federal protections on which it's built, are still the law of the land. Next slide, please. So it's really important to note, in California, we actually have stronger civil rights protections. In California, no person can discriminate on the basis of sex, race, color, religion, ancestry, national origin, ethnic group identification, age, mental disability, physical disability, medical condition, genetic information, marital status, or sexual orientation. Under the state laws, if you are in any of these categories, you cannot be denied full and equal access to the benefits, or be subjected to discrimination under any program or activity that's conducted or operated or administered by the state. This includes, but is not limited to, Medi-Cal and the insurance entities that participate in Covered California, which is our state exchange. These provisions are still in full effect regardless of the federal actions taken. Next slide. With regards to language access, more specifically, SB 223 by Senator Atkins, Pro Tem Atkins, sponsored by CPEHN, still requires plans to notify their members in the top 15 languages spoken by Californians of the state's stronger anti-discrimination protections, as well as the availability of free language assistance services. And that includes oral interpretation and translation, as well as auxiliary aids and services. This is really important in California, as 44% of Californians speak a language other than English at home. And as we know, over 200 languages are spoken in the state. California law also requires health plans to provide translations of vital documents in the top languages other than English spoken by the plan's enrollees. And additionally, a law passed in 2003, SB 853, requires health plans to come up with policies outlining how they will provide quality, accessible interpretation to their enrollees at no cost. And so essentially, our state laws are still in place. The federal protections are in place, and I'll turn it over to Amanda and to our other speakers to talk about other aspects of the role. Next slide.
Everyone, thanks so much, Carrie, and thanks to CPEHN and to Dretta for all the work that that you've done on ensuring that California law codifies these protections and has these strong non-discrimination provisions, and for the work that you've done over the last weeks to make sure that our state regulators were ready to respond to the Trump administration. And as Carrie mentioned, my name's Amanda McAllister-Woolner. I'm the director of the California LGBTQ Health and Human Services Network. I use she, her, hers pronouns. You know, one thing that we have noticed in the couple of weeks since the Trump administration released its final rule is just the ways in which you know, the administration has been successful in causing confusion and in causing people to be fearful that their rights have been repealed or that they will no longer be able to access healthcare. We've heard from a number of folks in the weeks following the final rule being issued, asking, what does this mean for me? What does this mean for my gender affirming surgery that's scheduled, in a few months? Does this mean that I no longer have access to health insurance, to healthcare? And so we think, it's really important to emphasize that here in California, access to transition-related care is still protected, and discrimination based on sexual orientation, based on gender identity, is still illegal. And in reality, despite the Trump administration's many attempts to change the definition of what prohibited discrimination on the basis of sex means, the underlying statute, as Carrie said, and as Kiran said, remains the same. And the courts have affirmed time and again that discrimination on the basis of sex is prohibited. Monica, would you mind going back 2 slides real quick? One more, perfect. So this is section 2561.2 from the California Health and Safety Code that codifies California's protections that go above and beyond what even we had under section 1557 in the law. And this is part of the reason why we can be so confident in saying that healthcare discrimination is still illegal, and anyone who's experiencing that should take measures to ensure that you are able to access that healthcare. So this section says an admitted insurer shall not discriminate on the basis of an insured or prospective insured's actual or perceived gender identity, or on the basis of that insured or prospective insured is a transgender person. So what does this mean? Next slide, please. So the section goes a little bit further, and California regulators have gone further in laying out exactly what is not allowed, as a result of California's non-discrimination protections. So first off, next slide. Denying, canceling, limiting, or refusing to issue or renew an insurance policy because someone is transgender, gender nonconforming, non-binary, that is all prohibited under California law. So, you cannot be denied an insurance policy in the beginning based on your gender identity. Next slide. Additionally, you can't be charged a higher premium, you can't be charged a higher fee based on your actual or perceived gender identity. And that is for all policies, all healthcare policies in the state. Should be, your fees cannot be based on gender identity. Next slide. Additionally, person's actual or perceived gender identity or a person being transgender, being non-binary, cannot be counted as a pre-existing condition for which coverage will be denied or limited. We're lucky with the Affordable Care Act that, we don't have to worry too much about pre-existing conditions anymore. But, California law further codifies that, there can't be restrictions to transition-related care or to other healthcare services, cannot be limited based on a person's actual or perceived gender identity. Next slide. And What's also prohibited under California law is denying or limiting coverage or denying a claim for services due to an insured person's actual or perceived gender identity, or because that person is transgender. So this includes healthcare services related to gender transition. And as long as those same services are covered for other reasons. And this is based on medical necessity determination between a patient and their doctor. But any healthcare that is covered by an insurance plan for any reason that's deemed medically necessary is covered. And that has been the case in California, and that continues to be the case even with the changes to the Section 1557 rule that were released. And finally, also to mention, next slide, there has been a lawsuit filed appealing the final Section 1557 rule by Lambda Legal. It was filed just last week, and basically laying out that the act itself explicitly protects against discrimination in the provision of healthcare services, and that the new rule that was released a few weeks ago, subverts the intent of the original law. And with the decision in Bostick a few weeks ago that found that Title VII sex discrimination does include discrimination based on sexual orientation or gender identity, I think there's a really good reason to believe that the courts will see that any other interpretation of discrimination on the basis of sex is subverting the intent of the law. So this will continue to work its way through the courts, but there is hope that even at the federal level, in the even potentially near future, we may see some change of course on Section 1557. And I think with that, I think we're going to Sylvia next.
Thanks, Amanda. Thanks for the presentation, and thanks for your leadership in this space. It's just so important. So we are going to Sylvia next. So Sylvia Yee is a senior staff attorney at the Disability Rights Education and Defense Fund, a close partner of CPEHN, and she is going to talk really about what the rule means and what the laws are in California that impact people with disabilities. So Sylvia, thank you so much for being here, and let me hand it over to you.
Thank you, Kiran, and thank you, Amanda. I'm just going to start with the slides. As mentioned, I'm a senior staff attorney at DREDF, and I also use she and her pronouns. So for going to my first slide, if we can move on to that. Just a very brief recap on what has already been said, that despite the changes to the federal rule and the new Section 1557 rule that is not in effect yet, but if it's allowed to continue unimpeded, would be in effect in roughly 60 days. Non-discrimination in healthcare here in California does reach private insurers. It does include sex, gender, gender identity, gender expression, and sexual orientation. And it requires non-discrimination, language assistance, and effective communication notices and taglines. So I'm going to focus in a little more on the implications of non-discrimination in healthcare for people with disabilities. And particularly, I would like to look at that word benefit design, because non-discrimination in health insurance includes non-discrimination in benefit design, which is the coverage content of a policy, what is actually in a policy. Next slide, please. So the actual benefit design provision in the 1557 rule does actually still remain. It's still there. And it even though much of the other content around it that dealt with sexual orientation and gender identity and transgender protections is gone. And that is very, very unfortunate because all of those illustrations helped to illustrate what is meant by benefit design. Fortunately, here in California, we do still have language around benefit design as well. And that language explicitly prohibits marketing practices or benefit designs that, quote, have the effect of discouraging the enrollment of individuals with significant health needs, end quote. So discriminatory benefit design can include things like placing all of the drugs needed by people with a particular health condition, let's say HIV or AIDS, placing all of those drugs on the highest copays. That's a benefit design decision, something that places a medically necessary treatment and puts special costs on that. Or a benefit design decision to not cover medically necessary treatments of a certain kind or a certain kind of equipment that's needed by people with a particular kind of disability. The reason that benefit design and those words are so important to people with disabilities goes back to a number of cases that were decided under the Americans with Disabilities Act, which has the ADA has a certain provisions that protect to some extent healthcare insurers. It protects their actuarial decisions. And a lot of people, I think, have come to accept before the Affordable Care Act, just came to accept that the way insurance was designed, it's like it happened in a black box. They make business decisions, they use some kind of formula, we don't really know what's happening, and then we just have to accept what comes out. And unfortunately, a number of court decisions seem to support that kind of view. For example, it made the analogy that, yes, you can't discriminate against people with disabilities. For instance, it's like insurance is like a shop. You know, you can't stop a person with a disability from entering the shop. That's discriminatory. You can't say, I refuse to sell insurance to you because you have cancer, or I refuse to sell insurance to you because you use a wheelchair. That's discriminatory. But nothing makes the shop carry the kinds of products that a person with disabilities needs. For example, and this was actually said in cases, you could have a camera shop and you can't stop a person who's blind from entering the shop, from wanting to check out the merchandise, but you don't have to carry a camera that a blind person could use. And that was used to describe like policies, health insurance policies. Okay, you can't refuse to sell a policy to a person with a disability, but there's nothing to stop you necessarily from not covering all kinds of treatments and benefits and coverage that a person with disabilities would need. So this was a very big hole in the coverage in health insurance coverage. And it was very, very important to people with disabilities when the Affordable Care Act came out and when protections and regulations adopted in California in 2013 came out that recognized that, no, you can't have benefit designs that have the effect of discouraging the enrollment of individuals with significant health needs. Moving on to the next slide. It's an exciting thing for California because we think the state does have the authority to clarify what discriminatory benefit design actually means. So a refusal by insurers to cover medically needed preventive care, or arbitrarily placing special limitations or costs on something like pregnancy services, or transgender services, or durable medical equipment such as wheelchairs, or access to cancer specialists. All of these kinds of benefit designs and decisions hurt an identifiable group of people on the basis of characteristics that are protected by law. Next slide, please. So I just would like to spend a couple of minutes, or hopefully just a minute, on how non-discrimination can be enforced on any of the bases that Amanda or Carrie talked about, or that I'm talking about now. There are multiple means. We have different routes here in California. One is actually to file a grievance with your health plan if you have a managed care plan or even just a general insurance plan. If you think that they are discriminating against you on the basis of a protected characteristic in California, you can and should file a grievance with them. And one of the reasons to do so is that filing that grievance can be a required first step for some of the other complaint routes on this slide. For here in California, you can also file a complaint with the Department of Healthcare Services, the Office of Civil Rights. Now, the grievance with your health plan is not necessarily a prerequisite for this, but for filing a complaint with DHS, you can just tell the Office of Civil Rights that you feel you've been discriminated against if it's in Medi-Cal, and they will take that complaint. You can also contact California's Department of Managed Healthcare or California's Insurance Commissioner, and I believe Commissioner Lara will be on later and will be speaking more about the Insurance Commission complaint. But as far as the Department of Managed Healthcare, it is possible to file for an independent medical review if you think that a decision you've been discriminated against in being denied a particular service or treatment. And you can also file a complaint against a managed care plan that you are a member of. And finally, because we have Section 11135 in California that protects Californians from discrimination under any program or activity that is conducted or operated by the state or by any state agency, or is funded directly by the state or receives any financial assistance from the state. So that includes a lot of health plans, both health plans that are in Medi-Cal, health plans that participate in Covered California. And that's another possibility of filing a complaint if you feel you've been discriminated against with the Department of Fair Employment and Housing. And despite their name, they don't only deal with fair employment and housing complaints. Thank you very much. I think that concludes what I was going to speak on, and I'm going to hand it back to Kiran.
Thank you, Sylvia. Thanks so much for providing all of that context and information that's so critical for us to understand this issue. I just want to remind folks as we get close to the end of the webinar, if you have a question, please put it in the question function on the webinar, and we will hope to have time to address it at the end. So thanks for doing that. I'm now very pleased to introduce our next speaker, Insurance Commissioner Ricardo Lara, who's here with us to talk about the function of the California Department of Insurance in all of this as a really important player in ensuring that Californians remain free from discrimination in their health care. And Commissioner Lara also previously served in both the Assembly and the Senate as a great champion for these issues and for ensuring that we had consumer protections for LGBTQ communities, for immigrant communities, and for communities of color. And so we're really grateful to him for championing these issues. And welcome him to our webinar today to share a little bit about the Commission's role and his perspective. And so, Commissioner Lara, I'm going to turn it over to you now.
Thank you. Thank you so much. It's great to be with you all virtually. I'm proud to be California's Insurance Commissioner. Our department regulates PPO coverage in individual, small market, small group, and large group policies throughout the state of California. As you all have been talking about the Trump's administration rollbacks, really rollbacks of our civil rights and a direct attack on communities who already suffer greater levels of discrimination and lack of access to healthcare, and one that I, in the Department of Insurance, will continue to resist. As other speakers have mentioned, the final rule in part eliminates existing federal protections against discrimination on the basis of sex. This federal action will have a disparate negative impact, as we already know, on women, persons of color, persons in our LGBTQI communities, and people with disabilities, and persons whose primary language are something other than English. If I think we have a slide available, I wanted to put up the first slide. You know, the beauty as the previous speaker was saying, in California, we have robust protections. As soon as the federal rule was released, I issued a notice to all California health insurers stating that they must continue to comply with California's anti-discrimination laws, despite the recent Trump administration's rule of eliminating our longstanding federal protections against discrimination on the basis of gender identity and sexual orientation. So we want to make sure we moved swiftly to make sure that the health insurance companies knew that they had to abide by California law. The federal rule, as we know, does not preempt state law. Health insurance is regulated by the California Department of Insurance, and it remains subject to California anti-discrimination laws. That's clear. That's something I really wanted to point out. Consequently, health insurers must continue to comply with existing anti-discrimination standards in California law beyond the minimum requirements of the federal level, which is also an important note to make. And California law provides substantial protections against discrimination based on sex, gender identity, gender expression, sexual orientation, as shown on the slide. The Department of Insurance will vigorously enforce these and other existing provisions of California law to protect Californians who are wrongfully being discriminated against. We will continue to fight to ensure all Californians, regardless of their sexual orientation, gender identity, English proficiency, or disability, have access to quality healthcare, and will continue to vociferously defend this right in our courts. The recent Supreme Court ruling in Bostock further demonstrates, I think, that Trump's administration's final rule is on the wrong side of history, equality, fairness, and quite frankly, the law. So, you know, and to the extent that a person's health coverage is subject to federal regulation, such as employer-based ERISA plans, the final federal rule may impair the ability of people in these groups to access healthcare and facilitates, you know, discrimination. The Supreme Court decision in Bostock supports a conclusion that such discrimination will be illegal in these federally regulated employer health plans, health ERISA plans, I should say. But you know, that matter is still being litigated. So you know, what do we do as a department now, given the uncertainty, the animosity people are feeling? If we can have the next slide, people who believe they've been subject to unlawful discrimination should contact our department, in particular our Department Consumer Complaint Center, which is where we collect all of our complaints, and we have follow-up and our investigation. We have over 300 investigators and agents that go out and investigate not only fraud, but discrimination in accessing health insurance. And please, we would ask you to give us a call. We speak multiple languages. The majority of our staff has been transitioned to telework from home, and you will talk to an individual. You're not going to talk to a recording. And that number is 1-800-927-4357. You can also submit a complaint through our department's website at insurance.ca.gov. And we're going to continue to stay vigilant. We're not going to, you know, roll back the great efforts we've made to expand healthcare, and at least we're not going to go down without a fight. So I want to thank you all for having this important discussion, and look forward to partnering with all of you as we continue to defend healthcare, access to insurance to every single Californian, regardless of where they come from, the language they speak, or their sexual orientation or expression or identity. Thank you so much.
Thank you, Commissioner. Really appreciate you being with us today and all of your work on this. And if I can just, before you hop off, throw the first question here to you, which is, can you just tell folks a little bit about what they should expect or what the process is like if they call your office to file a complaint?
Absolutely. So you call our office, you'll be, the phone will be answered by one of our insurance experts that can walk you through the situation you experienced, or if you have any questions regarding your health insurance or any coverage that you might have. And then we will help you open a case. And we will follow up and do our due diligence, contact the insurance carrier, and walk you through the process. So we're essentially there to help you understand your policy, what your coverage is, and take and do the initial intake, so that then we can then refer it to one of our another one of our insurance professionals, and then we'll definitely follow up with you. And of course, we speak multiple languages. Want to make people know that you could speak in the language that you're comfortable in, and that we will continue to be that advocate. My essential role as the elected insurance commissioner is to be the #1 consumer advocate in the state. And I hope many of you got your insurance reimbursement or your credit. Proud to say that we've, now it's been close to $1.2 billion that we've returned to consumers. And we're going to continue to do that, because that is what the position does. And again, we are the largest insurance market in the country, 4th in the world, and we will do everything within our power to make sure that we protect consumers.
Thank you. Thank you very much. Thank you for being such a strong advocate, and certainly encourage people to contact your office if they have any concerns. Thanks again.
Thank you.
So thank you. So we're just looking at the questions coming in here, and we do have time for a few of them. So I want to first ask Carrie and Sylvia and Amanda if any or all of you can talk about, in addition to this webinar, how are you educating your communities about the protections that remain in place in California? And the second part of the question from the participant is, how can I help?
I can jump in first, and then I'll pass it off to Amanda and to Sylvia. I'll just mention briefly that we have on our landing page, on the CPEHN landing page, specifically on 1557, we have a page there that you can go to that has links to the guidance and statements from our State Department, the Department of Insurance, the Department of Managed Healthcare, and the Department of Healthcare Services. And so we encourage you to go there. We also have a joint fact sheet that we have put together with Disability Rights Education and Defense Fund and the California Health and LGBTQ Health and Human Services Network, as well as the National Health Employment Law Program, that outlines a lot of what was said on today's call. We really encourage folks to check that out, check out our website, and feel free to download the fact sheet, and you can use that in your communications and education efforts as well. And then, I'll hand it over to Amanda, but we are, trying in many different ways to get the word out. And so this is one of a number of different activities and that we've been undertaking. So I hand it off to you.
Thanks, Carrie. And yeah, thanks for flagging the fact sheet, which I think is a great resource that breaks down a lot of the things we talked about today. We also posted a blog post on our website the day that 1557 came out that has most of the information that I talked about today, as well as links to the actual guidance from all of our insurance regulators in the state, and the 3 statements that came out in the days after the Trump administration's 1557 rule came out. So we do have that already up, ready to go, and accessible for folks. In addition, we're currently working to put together a Know Your Rights, access to transition-related care, and trans healthcare, one-pager fact sheet that looks at all of the folks, all of the different plans that folks can have in California, all of the different interlocking layers of protections at the state level, at the federal level, for whether it's, how does the religious refusal rule impact this? How does Section 1557 impact this? How does state law? We want to make, we're working to kind of collect all of that into one place so that people can understand, everyone can understand your rights when you go into a healthcare setting and be armed with, with the facts, with the code sections even, that guarantee you access to healthcare free from discrimination. And so we are hoping to get that out in the next few weeks, and welcome any other questions that folks have on or around access to healthcare that need to be addressed in that tool.
Hi, this is Sylvia, and just I guess a quick response to that. We also did put out something on Section 1557, the pending new rule, and we are a legal organization, and I think one of the ways that we think of educating people is to bring actions if possible. So we are actively looking for good benefit design cases, people with disabilities, people with significant health conditions who are facing coverage policies that do discourage them because things they need are just not covered. Their wheelchair that they absolutely need to be in the community, to function, to work, is not covered by their health insurance. We would think that is discriminatory benefit design, and that's the kind of action that we would be interested in hearing about. I know that litigation is not necessarily seen as education by everyone, but I think that for us, it definitely is a big part of education nationally and in California.
Thanks all of you. And sort of related to that, we also got a question, I think Amanda mentioned that other states may not have the same protections in place and may be more impacted by the federal rule change. And so the participant asks, are there any things that we can be doing to support our colleagues and to support consumers in other states?
I think that, for folks who are in other states, I think the lawsuit is, not just looking at the changes to the definition of sex, but is looking generally at the changes to Section 1557 and the kind of the strength that we had originally with the 2016 rule, and trying to restore some of those protections or clarify that that those are still the case. So I mean that's a big thing that that is happening right now to return those protections in other states. The other thing to note is I believe that, as Sylvia mentioned, this hasn't taken effect yet, but there's also a possibility that this rule could be rescinded if there was a substantial change in Congress and in the federal administration at election time. They do have the right to do Congress can do an administrative review on rules that were published within a certain number of days of a change in Congress and a change in administration. So, depending on how many session days we have between now and the election, it is possible that that this rule actually could be changed relatively quickly with the right set of circumstances after the election.
I think that serves as all of our daily reminder to get out the vote in November. So thank you, Amanda. Another question that we've gotten here is actually related to healthcare providers. And so the question is, what can healthcare providers be doing to help protect the rights of consumers? I don't know if there's someone who wants to take that.
I can say a little something, and then if Carrie or Sylvia want to add anything. You know, I think that you know, it is the kind of the first providers are to a certain extent the first line of defense for a lot of these things, and I think someone who provider who wants to you know, affirmatively defend non-discrimination protections, you know, can be I think firm with describing the medical necessity of you know, certain procedures, you know, medical equipment, anything that might be needed. And there's also, you know, a number of resources for providers who want to know how to appeal denials of care, how to describe medical necessity. The folks at Lyon Martin and the Transline have some of those resources of template letters that providers can use. You know, if an insurance company does deny transition-related care or you know, other necessary health care. So I think familiarizing yourself with that, but providers can definitely play a huge role in making sure that folks can access healthcare.
Yeah, I completely. Sorry.
Go ahead, Sylvia.
Yeah, just to completely support what Amanda said, I think that there are providers that have really been champions for people with disabilities, and especially by recognizing that health is a broad concept. It isn't just what's medically necessary is what stops you from dying the next day. I think we have definitely moved beyond that to an understanding of preventive health, of health that really actually helps an individual to be who they can be, the best they can be, living in the community independently, functioning well. And that's something that when providers educate themselves on that and are advocates for their patients, for really the health of their patients, it turns out to be the best, you know, one of the most important things that a person with disability or anyone can have on their side.
And just to add, I think I totally agree. And, you know, providers are so important. Also just, you know, even with the basic information around rights for individuals, I think one of the things that we've learned in talking with our community members is oftentimes people are not aware of their rights, in particular with regards to language assistance, but you know, to any one of these important rights, critical rights that Californians do have to accessing equitable care, it's even more important, particularly now with this, you know, federal rule change, that providers play a role in helping to dispel any confusion that individuals might have about whether anything has changed, which it hasn't. But whether there's any, you know, potential change to the rights of consumers. So, you know, we need everybody's help in making sure that that people understand, you know, that they still have these important and critical protections.
Thanks, all. That's really helpful. I think we definitely want to emphasize all the healthcare providers on this phone call have a critical role to play. I'm just going to take one more question because we're almost at time here. And the question is, and this is sort of about the process and what you should do if you feel that you've faced discrimination. The question is, I called my health plan about an issue related to this, but I haven't gotten a response, or I haven't gotten a satisfactory response, which I think is not an uncommon problem that we hear about, unfortunately. And so the question is, what should I do next?
That's a great question. And Sylvia, please feel free to jump in as well. I think that, you know, when folks call to make a complaint to a health plan, that's often the first step. You know, we know that things are not always resolved immediately or appropriately. And that is why it's also really important that we have other options. I think Sylvia's had one slide that talked specifically about that, and we do also talk about this in our fact sheet. But if you are unsatisfied by the response of your health plan, you can also contact the Department of Managed Healthcare. They have a helpline that will, you know, handles grievances and complaints. You can also contact, we heard from Commissioner Lada's office, you can contact the Department of Insurance. You can also contact the Department of Healthcare Services if you are a Medi-Cal recipient and have a problem with your plan. And then I think, you know, another option is the Health Consumer Alliance. And we do include the telephone number for HCA, the Health Consumer Alliance, in our fact sheet. Sylvia or Amanda, I don't know if you have anything to add to that.
This is Sylvia, and I was just going to add that I that is a problem we hear about, where you just are not. Sometimes it can take a long time even to get a no. There's this sort of in between kind of, well, we're considering it, we're thinking about it. Oh, have we not gotten back to you yet? And there's, and if that's just going on for a long time, file a complaint, file a grievance with the plan. And with all of these places, sometimes it can be confusing. You're not sure, do I have managed care? Is that what I have? Is it, I think they said they're a PPO. You're just not sure. But all of these places should be able to help you figure that out too. You don't have to have all the answers incoming, but as a first step, to file the grievance with your plan. So you're not giving me an answer. You're not, I mean, this is important to me. It's a matter of time, and you're just vacillating. You're not doing anything. File that complaint, or say, I'm assuming that you're saying no because it's been 3 months and nothing's happening. Or file that grievance and then go on to the other places and ask for help with figuring out what you should do because you're not getting the help you need.
Thank you. Oh, go ahead, Amanda. You want to add?
So I don't have a ton to add. I think that's exactly right. And if you can get a response in writing, that's always helpful in moving, moving things along through the other, the next steps in the process. Also, if your denial is related to transition-related care, there's a really great resource that we link to in our blog from Transgender Law Center that goes through all the different steps that you can take, that you'll need to take once you do hear from your health plan about a denial.
Thanks, Amanda. That's a really great addition. So we are at time, and I really want to thank our speakers first and foremost for joining, for lending your expertise. I think it's been tremendously helpful to hear from each of you. And I also really want to thank all of our participants for taking the time to join us and for your investment in this issue. Please do visit our website, and it sounds like Amanda's got a lot on their website, and Sylvia as well, for more information, for links to the different departments that can field your complaint, as well as to the fact sheet specific to this issue from our organizations, which is on the CPEHN website and is also linked in handouts on the webinar platform. So please do utilize those resources, and please make sure that everyone in your community knows what their rights are. I think this is, we're all in this together, and just so important to make sure that Californians know what their rights are, and that we continue to fight back against this blatant discrimination and attacks from the Trump administration. And so, as Amanda says, don't forget to vote. And thank you so much for joining us today, and please feel free to reach out if there's anything else that we can assist you with. Thanks, everyone.
Thank you.
Thanks all.